The House Committee on Government Operations will come to order. I just want to remind everyone, if you intend on speaking today on the bills we have, if you could please fill out a white card that's on the testimony table and make sure you turn it in to our clerk here. We do have a lot going on today, so we are going to be limiting testimony to about 3 minutes, so we'd appreciate that. Okay, Representative Vanderwall, I'm sorry, Mr. Clerk, would you take attendance?
Chair Begol.
Here.
Representatives Harris.
Here.
Vanderwall.
Present.
Fitzgerald.
Here.
McFall.
Here.
Mr. Chair, you have 5 members present, a quorum.
Thank you. Representative Vanderwall moves to adopt the minutes of the last meeting on March 13th. Without objection, so ordered. Okay, the first thing we're going to do is take up House Bill 4118. This bill would allow county drain commissioners to levy drain assessment on state lands. But first, we have an H1 substitute that corrects an error on page 3, line 2, by changing the word country to county. My understanding, Representative Schutte, this is the John Denver sub. Is that what that's correct?
Yeah, country roads can take us home.
Very good. Representative Harris moves that the H1 substitute be adopted. Mr. Clerk, will you please call the roll?
On the motion to adopt, Chair Begol.
Yes.
Representatives Harris.
Yes.
Vanderwall.
Yes.
Fitzgerald.
Yes.
McFall.
Yes.
Mr. Chair, you have 5 yeas, 0 nays, 0 pass. The motion prevails.
Okay, the substitute is adopted. I have 2 cards to read in. Not wanting to speak in support of the bill is Andrew from Michigan Farm Bureau. And we have another one here. Unfortunately, we're not going to be able to take testimony on it today, from Susan Julian. We did take testimony last week, and in the interest of time, Ms. Julian, are you here today? Okay, if you want to submit some written testimony, we'll include it into the record. You're welcome. Okay, now we'll be reporting House Bill 4118 out. Representative Harris moves to report House Bill 4118 with a recommendation as substituted. Mr. Clerk, will you please call the roll?
On the motion to report, Chair Begol.
Yes.
Representatives Harris.
Yes.
Vanderwall.
Yes.
Fitzgerald.
Yes.
McFall.
Yes.
Mr. Chair, you have 5 yeas, 0 nays, 0 pass. The motion prevails.
Okay, House Bill 4118 is reported with recommendation as substituted. Okay, next we'll be hearing testimony on House Bills 4233 through 4235 and House Bills 4238 through 4242. This is a package of bills dealing with foreign influence. We're going to start with House Bill 4242, which is sponsored by Representative Jamie Thompson. She couldn't make it today, but we're lucky enough to have her legislative director, Marla Braun, here to read in a letter from her. Ms. Braun, if you want to take a seat, proceed when you're ready.
Sorry, got to adjust that. Can you hear me? Okay, great. Thank you very much, Chair Begol and members of the committee. As you had mentioned, Representative Thompson was not able to make appearance before committee today. We thank you very much, and I'm just here to present her letter of testimony for House Bill 4242. Again, I am Marla Riley Braun, and I serve in her office as the legislative director. From Representative Thompson, she says, Chair Begol and members of the committee, thank you for giving me a moment today. I wanted to thank all of my colleagues that have worked on this very important package, as foreign influence is a Michigan issue along with a national issue. Protecting our health records from foreign influence and bad actors is not only extremely important, but it is urgent that we must act now to safeguard people's personal information. On a federal level, the Secretary of Health and Human Services is responsible for reporting data breaches, but currently we are behind the 8 ball with our state laws. In May of last year, a cyber attack hit 140 hospitals across 10 states, locking healthcare workers out of the electronic system and forcing them to return to paper and manual medical procedures that now currently use technology. In September, a cyber attack hit the University of Michigan's Academic Medical Center for the second time in 4 months and exposed the data of nearly 58,000 patients. These are happening frequently. Had these attacks come from one of our foreign adversaries and this data ended up in their hands, the results could be tragic. Ensuring that our medical care record technology is physically maintained in the U.S. or Canada, as my bill does, House Bill 4242, is a needed step Michigan should take to protect the personal and private health information of our constituents. It is my intent to work on additional legislation moving forward as more of these cyber attacks are impacting not only our hospital and medical centers, but our pharmacies as well. And this is from Representative Thompson. Our office wishes to also submit, along with this, if you need any information from where we sourced our information, we did go to the National Center for Civil Rights in the Department of Health and Human Services, which keeps records of these breaches.
Okay, very good. Do we have any questions from our members? Okay. Not seeing any questions. Thank you for coming in and reading the letter today. We appreciate it.
Thank you again, sir.
Okay, next we'll be taking up House Bill 4241. This is sponsored by Representative Hoadley. Representative, you want to come on up to the testimony table? Representative Hoadley's bills would prohibit the Michigan Strategic Fund from knowingly entering into an agreement for an economic incentive with an entity from a foreign country of concern. Representative Hoadley, if you want to tell us about that, go ahead and proceed when you're ready.
Thank you, Mr. Chair. Thank you, esteemed colleagues of the GovOps Committee. You pretty much summed it up. I'll be brief. I think we've seen in recent years the outrage from Michiganians with economic incentives coming from the Michigan Strategic Fund going to fund these foreign entities, which are known bad actors. Those entities consist of the Russian Federation, the Islamic Republic of Iran, the Democratic People's Republic of Korea, North Korea, the Republic of Cuba, the Venezuelan regime under Nicolas Maduro, and the Syrian Arab Republic, to name a few. We've seen this over the last few years where we've gotten much public outrage when we've seen tax dollars there. This is a matter of national security, as well as, of course, that of the Michiganians that we've sworn to protect. As a military veteran, I take this very serious, and this part of the package I think is essential. And with that, like I said, I was going to be very brief on that, and I welcome any questions.
Okay, Representative Vanderwall.
Thank you, Mr. Chair, and thank you, Representative. You know, reading through the bill and then hearing your testimony, my question is, can foreign entities be added to your list? Right now, it's pretty specific. I guess my question is, if something hit the alarm list or hit of national concern, would that be added to your list, or would we have to come back to amend your legislation?
As it's currently written, we would have to amend that. These are specifically listed, and there isn't a segue there for adding.
Okay, Representative Fitzgerald.
Thank you, Chair. Thank you, Representative, for coming to testify today. A question about really understanding that we have to sign this affidavit, or someone would have to sign the affidavit to attest that the recipient or applicant is not a foreign entity. Is that in part or in whole? So my curiosity would be, is this, if there is a, say, minority share in that company, is it is that allowable? So if it was a 75-25, or they had a 49% share in a company, would that disqualify them?
It would pertain to a majority ownership, and let me point out too that it's knowingly entering into one of these agreements. So that does make it pretty broad when it comes to, board members and other entities that are combined.
Okay. Yeah, I was curious more, and as well, about different liability shields and ways that people can potentially even mask their intention of that, or mask their ownership stake or their relationship with any of these organizations. Is that of concern?
It's of course of concern, but again, this really just focuses on the upfront value of these entities, and I think for the most part, when we enter into these agreements, it's fairly public knowledge of who these people are.
Okay. Well, thank you for your work on this bill. Appreciate it. You coming in today and telling us about it.
Thank you.
Okay, next we're going to be taking up House Bill 4238, which is sponsored by Representative Jenkins Arno. Welcome. House Bill 4238 amends the revised school code to prohibit public schools from entering cultural exchange agreements under certain conditions from a foreign country of concern. It establishes the Foreign Influence of State Institutions of Higher Education Act to outline criteria for state institutions of higher education entering cultural exchange agreements or anything of value from a foreign country or concern. So if you'd like to proceed and tell us a little bit about that.
Yes, thank you, Mr. Chair and members of the committee, for the opportunity to speak to House Bill 4238. This bill would amend the school code to do four things. First, it would prohibit public schools from entering into agreements with or receiving grants from a foreign country of concern if the agreement or grant limits the public school's ability to enter into contracts, allows curriculum or values to be directed or controlled by that foreign country of concern, or promotes an agenda that would be detrimental to the safety and security of the United States or its people. Secondly, it would require that any cultural exchange program agreement that a public school would like to enter into with a foreign country of concern be shared with a federal agency that oversees national security. Number three, if it is determined that the cultural exchange agreement would be detrimental to the safety and security of the United States or its people, the school would not be allowed to enter into that agreement. It also prohibits public schools from accepting anything of value that is conditioned on the school's participation in a program or other endeavor that promotes the language or culture of a foreign country of concern. I've already heard the list of countries of concern, but I can go over those again if you need to. It's past time that we ensure that foreign countries of concern have zero influence over our kids. House Bill 4238 is a straightforward, common-sense measure to make sure we keep countries of concern out of our educational system. One of the core functions of government is to protect its citizens. The most valuable of our citizens is our kids. I ask you to vote yes on House Bill 4238. Thank you.
Thank you, Representative. Representative McFall has a question for you.
Real quick, where it says, where you mentioned about it promotes an agenda that is detrimental to the safety and security of the United States or its residents, how is that defined exactly? As to, like,
Well, I think that
it seems kind of like that could be interpreted broadly to me.
Yeah, there have been examples of that, like the Confucius Institute was a program that schools have implemented that is actually a propaganda piece of the country of China. And so that is something that, would kind of do that. It promotes it in a way that is, putting that forward above the interests of the United States. So I don't have a very specific definition of that, but it would be, kind of going along with what is on the national level, what they would consider as detrimental to the safety and security of the U.S.
Okay. It just seems like that would be ripe for abuse. So, but I appreciate it. Thank you.
Thank you.
Representative Fitzgerald.
Thank you, Chair. Thank you, Representative, for coming in to testify. I have real questions about point C, section 1, subsection C, promotes an agenda that is detrimental to the safety and security of the United States or its residents. I guess I'd like to maybe see what clarity you can provide about agenda, detrimental, and safety and security. Is it our physical safety? Is it? I guess there's a lot of questions that are drawn up from that point.
Okay, well, I know we have had examples of, students that have come to this country who have been found taking pictures around Camp Gaylord and things like that, where that's our military installation and things like that. Places where they can go, things that they are doing that would maybe be able to send what we're doing in our military to their country, their homeland. We just want to make sure that those things are not, going to be happening here in the United States through our school systems.
And so who is it that would then, I guess, enforce or determine if an agenda is detrimental to the safety and security of the United States? Is that a Michigan organization? I know that we have to report this to a federal organization that's tasked with national security, but I don't know how the enforcement of this would actually be conducted.
It would ultimately be on the federal level, but the Michigan would be working together with the federal level to ensure that those things are not happening here.
Has the federal government asked for this? Asked for us to do this at the state level then?
I don't believe so, but I think we on the state level as legislators need to ensure our safety and work together with the federal level to ensure the safety of our state and our nation, so.
Thank you.
Okay, thank you very much.
Thank you.
Not seeing any further questions. Okay, next we'll be taking up House Bill 4235. Representative Schmidt. Is Representative Bruck here today? Okay, unfortunately, we were hoping to have some testimony from him today, but he has not yet arrived, so we'll come back to him if he's able to make it. Okay, let's take up House Bill 4240, sponsored by Representative Schutte, so I know he's got a couple things he's got going on. Representative Schutte bill establishes criteria for public bodies accepting and disclosing gifts or agreements with foreign countries of concern. Representative Schutte, the floor is yours.
Well, thank you, Chairman Bagol. Thank you, Vice Chair Fitzgerald and Harris, members of GovOps, having me 2 weeks in a row in front of your esteemed committee. I hope I don't wear out my welcome, but I appreciate the opportunity, especially to testify today in support of my legislation, House Bill 4240, which prohibits state agencies and local governments from entering into constraining agreements with foreign entities of concern and requires that our public bodies disclose gifts and agreements they enter into with a foreign entity of concern. And, when talking about the importance of this legislation, I'd like to appeal to my previous work as an intelligence officer with the Department of Defense. And, in that role, we would monitor and analyze how nations like a China, a Venezuela, North Korea would try to gain influence, control, and manipulate other countries across the globe. And so I see that very concerning now as a member of the state legislature when we see those same types of activities and attempts to undermine our national security happen at the state level across the country and at home here in Michigan. And I can tell you, these countries, they don't play fair. They use every single lever of power, be that economic, cultural, or coercive, to jeopardize our nation's strength. And we've seen, obviously, these instances that some of my fellow members have talked about. We saw the espionage operation near Camp Grayling. We've seen blacklisted companies establish footholds in Michigan at taxpayer expenses. And we've seen an expansion, as my colleague Nancy Jenkins-Arno mentioned, of Confucius Institutes in our schools and colleges that have demonstrated attempts to bend and influence and contort curriculum against the United States. So, when I worked as an intelligence officer with the Department of Defense, I had a security clearance. And that meant getting that clearance required disclosing a lot of personal information and subjecting myself to limits on the types of gifts that I accepted and the relationships that I maintained. And that was because I had the honor to serve my country and was part of the public trust. I think that when we're asking our government institutions to similarly act in the interest of our national security, put America first, I think that's an important step to take. And I would welcome any questions from the members of the committee.
Representative McFall.
Thank you for coming in today, again. I have a quick question about, the bill seems to allow a county prosecutor or the attorney general to go after. Why a county prosecutor and not just have it at the state with the attorney general's office?
I think, you know, if again, it allows a county prosecutor in the event that there has been a state agency has demonstrated there is a violation. If there was something that occurred in, you know, Midland County, for example, and there was an instance of, you know, or a bad action taking place, we'd want our county prosecutors, again, who are in the public trust, who have this legal authority to be able to do so. So I mean, if it's a violation of state law, we oftentimes allow our county prosecutors to enforce and act on that.
Okay.
So,
Thank you.
yeah.
Okay. Seeing no further questions, thanks for coming in, Representative. Appreciate your testimony. Okay, next we're going to take up House Bill 4233, sponsored by Representative Johnson, and 4235, sponsored by Representative Meerman. If you'd both like to come up to the table. Okay, these bills would prohibit foreign persons from owning or acquiring agricultural land in Michigan, and foreign principals from owning or acquiring land near a military installation. Before we get started, though, we have an H1 sup for House Bill 4233. It will narrow the scope of the bill to foreign principals to foreign countries of concern. Representative Harris moves that H1 substitute for House Bill 4233 be adopted. Mr. Clerk, would you please take the roll?
On the motion to adopt, Chair Bagol,
Yes.
Representatives Harris,
Yes.
Vanderwall,
Yes.
Fitzgerald,
Pass.
McFall. Pass. Mr. Chair, you have 3 yeas, 0 nays, 2 pass. The motion prevails.
Okay, welcome, representatives. Would you like to take a few minutes and tell us about your bills?
Thank you, Chairman Bagol and the committee. Appreciate your time. I'm testifying today in support of House Bill 4233 as substituted. This bill is a critical step in safeguarding Michigan's agricultural lands from foreign entities that may not have the best interests of our state, our farmers, or our national security. Michigan's ag industry is one of the state's most vital economic pillars, and my community is an ag community. Our farms provide food security, jobs, and economic stability for countless residents. However, there's growing concern about foreign ownership of ag land, particularly by entities from countries that may pose economic or security threats to the United States. This bill seeks to address that concern while ensuring fairness and due process for those currently holding land. House Bill 4233 establishes clear and necessary restrictions on foreign ownership of ag land, specifically targeting entities associated with China, Russia, Iran, North Korea, Cuba, Venezuela, and Syria, countries identified as foreign countries of concern. The legislation ensures that foreign principals from these nations cannot purchase or acquire ag land in Michigan moving forward. It also requires foreign principals who already own such land to register their holdings with the Secretary of State, enhancing transparency and accountability. Importantly, the bill includes reasonable exemptions to prevent undue harm to Michigan residents and businesses. For example, foreign entities that inherit land through devise or descent are granted a 2-year period to divest. And ag land acquired through legal debt collection processes must also be sold within 2 years. These provisions ensure that individuals and businesses acting in good faith are not unfairly penalized while still maintaining the integrity of the legislation's intent. This House Bill 4233 also establishes enforcement mechanisms to uphold these provisions. If a foreign principal is found in violation, the Attorney General is authorized to initiate legal proceedings that may result in divestment or escheatment of the land to the state. Furthermore, failure to register ownership carries a civil penalty, reinforcing compliance. This bill is not about creating unnecessary barriers or fostering anti-foreign sentiment. It is about protecting Michigan's resources and ensuring that our agricultural lands remain in the hands of those who are invested in the well-being of Michigan and the nation. It is about prioritizing food security, economic stability, and national security. I urge my colleagues on this committee to support this bill to protect Michigan's ag industry, ensure transparency in land ownership, and secure our state's economic and natural interests for generations to come. Thank you. I welcome any questions.
Representative Bierman?
Thank you, Mr. Chairman, members of the committee, for the opportunity to speak on House Bill 4234. This bill will establish a prohibition on the ownership and purchase of land near a military installation or key facility in Michigan. Here, a foreign principal refers to the government official, political party, organized structure under the residence of foreign countries of concern. These countries of concern are defined and limited to China, Iran, Russia, North Korea, Venezuela, Cuba, and Syria. Acts of foreign interference within our sovereign borders are increasing, and 10 years ago, we would have been in disbelief at the level of the interstate activity of foreign governments have launched as it relates to this bill. I'm talking about the 5 foreign national students charged in the federal counter-surveillance probe on Camp Grayling, the military facility. At the same time, the Taiwanese were practicing there. At the time, the charges were not lodged against these students, which led to the deliberate destruction of records and false statements. This whole incident was foreign espionage from the People's Republic of China, plain and simple. This bill is offering a solution when currently there are none to the problem. China is buying up U.S. farmland. That's a known fact. We know that this adversarial nation is keen to find vulnerabilities in our intelligent network. That's clear from the espionage at Camp Grayling. This bill is going to protect our interests here in Michigan by creating a prohibition on the sale and ownership of land near key facilities and military sites. And just to address a question I heard come up, so I haven't, seen or heard somebody directly call for all of these bills we have in front of us, but I will refer the committee to our former director, Ray, of the FBI, and really his 10 years of work, almost 10 years of work on this particular issue. When you look at where he spoke and who he spoke to and what he was saying, he was often asking entities outside of the FBI, for instance, the mayors of the United States, to care about what China might be doing and how they might or might not be sort of participating unknowingly in assisting China. So in my mind, this is sort of stepping forward as Michigan and doing the part that we can. Thank you.
Thank you, Representative. Are either one of you aware if any of these foreign countries of concern have laws in place, like we're proposing here today, to prevent Americans from owning any property or things like that?
Certainly China, absolutely.
Okay.
They prohibit that, yeah.
Okay. Thank you. Okay, Representative McFall?
Thank you, Chair, and thank you for coming and testifying on your bills today. Who exactly would be responsible if property gets sold? Like, is it the real estate agent? Is it the seller? I mean, because this could, unknowing. I mean they have to do a lot of research to try to figure out if they are a foreign entity. So I'm just wondering who exactly would be held accountable if property did get sold.
Line 17 on page 5, a person that knowingly sells any interest in agricultural land or real estate property within 20 miles. I guess my point of reading that is knowingly. So you would have to participate in it.
Not the Realtor.
Okay, okay, because that's what, that, yeah, because even if it, I mean, you're still part of something, so I was just curious. I guess it isn't very clear to me, like who would actually be held accountable in that, because what would happen to the property then? Like if it was taken back, like if it was found to happen, like who, then where does the property go? Does it go into limbo?
I mean, it would have to be sold.
But who owns it? I mean, you're making the foreign country sell it?
They have to divest, yes.
Okay.
It goes back to the state, and the Attorney General would oversee that process through the circuit court.
Oh, okay. Thank you.
Okay, Representative Fitzgerald.
Thank you very much. A little bit of a two-parter, and the first one is just a clarification with the definition of key facility, any term defined under Section 552 of the Michigan Penal Code. Just for edification, what are key facilities? Military installations, I think I got a pretty good handle on, but key facilities?
Chemical manufacturing facility, refinery, electrical, utility, water intake structure, natural gas facility, gasoline, propane, liquid natural gas terminal, transportation, railroad switching yard, pharmaceutical manufacturing, hazardous waste, telecommunications, a facility substantially similar to the facility structure or station listed in the subsection. So I very briefly read over what that MCL is.
I guess in that, I'm concerned about, I mean, not concerned, but I'm intrigued by, I guess, the vastness of this definition, considering one of those is cellular towers. And I don't know that people know that they're within 20 miles of a cell tower. I actually don't know how long the range is of a cell tower. I mean, I got good reception. Thank you to my carrier. You know, I've got good reception, but I actually don't know if people know that or if that's something that's available when you sell. And so I think that there's some ambiguity and I guess just some intrigue about how we would actually enforce this and find that out. And my other question was, we do have a testimony here from the realtors voicing some concern about definitions and some ambiguity, but I think one of the points they raise about legal liability and legal exposure for American citizens who don't know, right? You get a phone call, says I want to buy your house, your land. I know in my community we get a lot of people who get unsolicited calls to see if they might buy their property, but if it's a private sale and somebody isn't aware of this law, but that they knowingly did that somebody from a different country or a country of concern, I should say, wanted to purchase the land, how do we get this more apparently known to people?
Well, I think let's start out by remembering that it's knowingly. So if you didn't know and it happened, you know, there's a process to sort of correct that. And we're talking about a pretty specific group of countries currently as, you know, defined by the Secretary of State nationally, State Department, sorry. Yeah, it's quite a comprehensive list, as you pointed out. But all of those, I think, can legitimately be compromised by somebody wanting to do them harm. I'm not sure you'd ever have a comprehensive list of all these facilities as far as dots on a map, but I think if it's known that, you know, a foreign entity of concern has some land and find out that it is close to this, then action can be taken.
Yeah, I think that the liability or the criminal concern for American citizens is something that I would like to have maybe broader discussion on. with regard to some of the written testimony we have here today. But I appreciate the answers and understand where we're trying to get here. Thank you.
Okay, Representative Vanderwall.
Thank you, Mr. Chair, and thank both of you for being here. Just a couple of questions, kind of follow-up to where we're at there with it's pretty broad statement on selling, especially ag land. My question is who's going to really truly oversee the situation of the sale? Because if we look at what's happening in today's world in the ag property, because I know this has happened in our area, a lot of hedge funds are buying the property for an investment piece. The problem is buried inside a hedge fund could be many different entities. And I guess my question is, where does that responsibility fall? If it's not with the realtor, it's not with the seller, who's going to oversee these lands that are being sold to verify that these hedge funds aren't of a foreign nation that we disallow?
The responsibility is actually with the seller, and yet it's knowingly. Anytime we roll out a new law, there's going to be a gray area, an area open for interpretation. This is in alignment with federal law and precedent. So the Secretary of State and the Attorney General, through the circuit court system, will oversee this and give judgment. And there's certainly a place for one defending oneself through our regular justice system that we always hope works the way it's supposed to, and gives discretion to those who have unknowingly sold it to an investment firm that had foreign entities, principals of these countries of concern. This is only a few countries, but they're significantly, in their intentions, it seems, are significantly adverse to the American way of life and our freedoms and our sustainability as a country. So it's not wide sweeping, but it's just guarding against those bad actors. It will be worked out in the courts, and it could be messy or it could be very clean cut, but this will be
Could
laid
I
out.
follow up, Mr. Chair? And I appreciate that, and I will tell you that a lot of the farm owners that are in my district have expressed major concern on what this potentially will do, not this bill, but what's happening right now. They, their fear is that we're going to strip all farmland, and once the farmland has disappeared, they control our food supply. I'm just kind of digging at making sure that when we put something in place that we actually have, somebody in charge or whatever it's going to be. We can't, if we kick it to the Attorney General, my concern is, number one, we're going to overload anything that's sold. It could either delay the sale, or it could, drive this, end the sale or whatever it happens to be. I just want to make sure that what we're doing, that we're prepared to make sure that we have the answers. So I appreciate that, and we can talk offline.
Thank you.
Okay, Representative Harris.
Thank you, Mr. Chair. Hello, welcome to the committee. Thank you guys for being here. Conceptually, I'm on board. So my question is, and I think we've had some good kind of vetting here, and maybe it's something that we can potentially firm up if we think there's a hole, but is there, with either of these bills, is there a triggering mechanism that would cause, whether it's the AG's office or Secretary of State, to initiate an investigation or to actually have some oversight on checking to see if these people are actually purchasing land and in violation?
Well, the Register of Deeds is involved, and registration with the Secretary of State. The farming community, this may not be the answer that's complete for what you're asking, but the farming community, their antennas are up. they are very concerned, like Representative Vanderwall mentioned, that this will not remain farmland. We will lose our first or our second greatest industry in the state, and you put a chokehold on local food supply, we're at their whim. So there's a lot of eyes on this right now. It will take possibly just the farmers keeping tabs. They want to keep tabs on this. They feel this is helping them sustain the farmland when they pass on. A lot of them, it's 4 or 5 generations. They don't know what's going to happen when they're not here. So the enforcement is key to this. But so far, the advice that we've been given is work through the Secretary of State and Attorney General. That may not be perfect, but we have to have a justice process to give fair balance.
So in theory, it would just basically be somebody reporting a potential issue?
Yeah, or the
That would
Register
trigger
of Deeds
something.
catching it because they oversee at the most local level
Okay.
the land and the sale and the purchase.
Okay. Thank you.
Representative McFall?
Thank you, Chair. I appreciate being able to ask one more question. Do you know if this has this passed anywhere else, and has it been challenged? Just because I know that the alien land laws have been deemed as being unconstitutional when you single out groups. So I'm just curious, has this been passed in another state where it has not been challenged?
It's my understanding that there are 15 other states that have laws that are similar to these, not exactly the same.
And none of them have been challenged as being constitutional?
No.
I haven't, maybe there's a case making its way through, I don't know. I mean, this is fairly recent in the last couple of years, I would say, for most of them.
Okay.
Not that we're aware of.
Okay.
Federal law and precedent has been set with these states. That's why this seems like a continuance and showing that we're in compliance with federal law.
Okay. Thank you.
Okay, nice job. Thanks for your testimony. We appreciate it. I have a number of cards to read in regards to 4233 and 4233 and 4234. The first one, not wishing to speak in opposition of the bill, is Mark Kalagos. Not wanting to speak neutral on the bill is Rebecca Park of Michigan Farm Bureau. Not wanting to speak opposed to the bill is Daniel Hurley of the Michigan Association of State Universities. Not wanting to speak in opposition to the bill is Dawn Crandall of Home Builders Association of Michigan. Not wanting to speak in opposition to the bill is Isa Vera Rosa from Asian Law Caucus. Not wanting to speak in opposition to the bill is Frank Foster of Equality. And we have a number of people who would like to speak on the bill. The first one on our list here, is it Sean Cecil, Michigan Realtors? Good morning, Sean. Go ahead and begin when you're ready.
Good morning. My name is Sean Cecil. I'm with the Michigan Realtors. I know it looks like Shawan, but it really is Sean. I believe y'all already have our written testimony, so I'll make this brief, and I know that y'all have already addressed some of the issues that we've brought up. While these bills aim to restrict foreign ownership of certain properties, they do need revisions to avoid unintended consequences. First, the definitions, as was brought up, of key terms differ between the two bills, creating confusion in interpretation and enforcement. Second, these bills do not exempt primary residences, which could create unnecessary barriers for illegal immigrants and long-term residents seeking home ownership. Third, HB 4234 creates legal risks for real estate professionals. It penalizes those who knowingly sell restricted property, but lacks protections for realtors acting in good faith. They should be explicitly exempt unless they have actual knowledge of a violation. I know that that was an issue that was brought up. I believe maybe a line exempting, being more specific, would be would actually really help that issue. Finally, HB 4234 requires buyers of properties within 20 miles of military sites or key facilities to sign an affidavit stating they are not foreign entities. This provision raises enforcement concerns and could create administrative burdens. We're in talks with the bill sponsors. Where obviously we want to be a resource for everyone as these bills move forward. And on that, I'll open up for any questions y'all may have.
I don't see any questions, so thanks for coming in. Oh,
I was so
Representative Fair,
close.
I thought you were out of it. Easy, didn't you?
You almost got out of your shot. And I haven't noticed it before, but you throw those y'alls in because you're from Louisiana, right?
Yes, sir.
I heard that in there. Okay.
I can't tell you how many times people say, yeah, we've counted, and it's going to be a drinking game in the future.
You know, I'll just ask this. You know, I think that there's some questions about that primary residency exemption and how this actually might be a barrier to, like you said, communities like legal immigrants who are coming here to join the American experiment, and where those properties exist. I think that there was some conversation ahead of committee today talking about university students, whether they be undergraduate, graduate level, doctoral students who are coming to be a part of our institutions and what they can provide there. I'm saying this in the sense of, do you have an indication that the primary residency exemption would ultimately, I guess, impact the economy of Michigan, that if that didn't come into place, could it actually impact our economy?
Oh, very much so. So we've been in talks with some of our Ann Arbor realtors that they said that this would greatly impact their business when it comes to around universities. And I would assume it would also around MSU. We promote free market, and these bills would essentially tell us also sellers who they can sell their homes to. So.
Okay, thank you very much.
Thank you, or thank y'all.
Okay, next we have Autumn Smith wishing to speak in support of the bill. Miss, unfortunately, I'm going to have to limit you to 3 minutes in the interest of time, and we have a number of people who'd like to speak today.
Thank you. I'll try to summarize it. I gave my written testimony to the clerk before I came.
Very good, thanks.
And mine can kind of summarize all the bills I want to talk about. What I want to focus on is some of the things that were already mentioned about the farmland. My concern has to do with the CCP influence in the state of Michigan. When foreign powers like the CCP start buying up the land, we're not just losing control of the dirt, we're handing over a piece of our future. The CCP isn't a private investor looking for a good deal. It's a government with a track record of strategic maneuvering to expand its influence, often at the expense of others. Foreign ownership of U.S. agricultural land has skyrocketed in recent years, doubling between 2009 and 2019. By 2021, entities tied to China own nearly 400,000 acres. Also, speaking on some of the other bills that were mentioned, including the education factor, I was a citizen journalist, and I was retaliated for exposing CCP influence in my local government. I was arrested and put in jail for simply writing an article about this. In the city of Battle Creek, our former mayor and our current assistant city manager has signed a letter with the People's Republic of China, very broad, very ambiguous, that has to do with higher education, learning institutions, selling off school buildings, money changing hands. And some of the entities that were registered with LARA, they're shady front companies that have to do, and they really go back to faceless names. And the concern is the city of Battle Creek has a military base there. They're also getting ready to do a missile defense system. But the thing that I found that was very worrisome was the shady business companies and stuff had to do with nano patent technologies. And I don't know if you guys are aware, but one of the things that the Chinese Communist Party likes to do, how they acquire patents, and if you don't already know, our patents are deemed state secrets. They will go in a backdoor way and purchase private businesses and acquire the patents that way. And I believe that is what is occurring. Hence, why would somebody like me, who has nothing to gain, who was just writing an article questioning my local public officials, which is one of the most patriotic things you can do as a citizen, would get thrown in jail for doing such a thing. So I am very concerned about all of these bills that have to do with foreign influence, and I support them all taking control of that and making sure that we get that out of our government. If you have any questions, I'd be glad to answer.
Okay, I don't see any questions, and thanks for coming in today and
Thank you.
giving your testimony. Okay, wishing to speak in opposition of the bill is David Martin of Michigan Land Title Association. Mr. Martin, are you here virtually? There he is.
I am virtually here.
Okay, go ahead, sir.
Thank you, Mr. Chairman, members of the House Committee on Government Operations. My name is David Martin, and I'm the president of the Michigan Land Title Association. Since 1901, our organization has represented members for the purpose of promoting sound and ethical business practices in the title industry, ensuring the integrity of the private and public system of land title evidencing, and advancing the right to transfer interest in real property without unnecessary burden or negative effects. We currently have as members 83 Michigan title companies, 24 professional members, and 10 underwriters. In a nutshell, we are the businesses and people that act as settlement providers and the title insurers for the transfer of real estate in Michigan. Over the past 2 years, we've seen many of these foreign ownership bills introduced across the country, and in fact, the American Land Title Association, our national trade group, is currently tracking more than 130 of these bills. I'm here to discuss the practical concerns our industry has about the bills as drafted. There are 4 areas of concerns when analyzing the impact of this legislation: who's restricted from acquiring property, what property is affected, what happens to title if a restricted buyer acquires restricted property, and who's responsible for enforcement. While these bills adequately address many of these concerns, there are a few areas which need clarification as to not disrupt title to real property. First, a fundamental concept in real estate law is that you cannot convey what you do not have. I must have marketable title to property in order to convey marketable title to my purchaser. As worded presently, these laws prohibit restricted owners from owning restricted property. The concerns for those of us who work with title to real property is whether a conveyance that follows from a restricted owner to a bona fide purchaser does not meet the definition of restricted owner, constitutes good and marketable title. We would appreciate language that clarifies that no title to restricted property is invalid solely because a party back in the chain of title constituted a restricted owner. Essentially, we would like to see a bona fide purchaser protection, which is quite common when dealing with other ambiguities and issues that arise with title to real property. It's one of the cornerstones in real property law. Second, valid lien holders and other interest holders, for instance, recorded easements, must be protected under the law. HB 4233 does not protect lien holders, and while HB 4234 does have a provision, it is ambiguous. When lenders loan money, they take a mortgage to secure a lien on the property so that they may be made whole in the event of a default. This usage of real property as collateral and wealth is one of the fundamental benefits of our economic system to consumers, and it needs to be protected. If a lender's mortgage can simply be ignored on the basis that a borrower turns out to be a restricted person and the state can simply ignore or extinguish their lien, then the availability of credit to consumers will dry up, and this could have an unintended effect of stifling the real estate market. In short, these bills should contain specific language that clarifies the interests of record will not lose their priority and are enforceable as determined by the recording statutes. Third, the law should be clear that the party responsible for determining whether a buyer is a foreign person, as defined by these bills, is the actual buyer. Title agents, title underwriters, and settlement agents are not in a position to make this determination, as that information is not available in the public record. And in fact, we are likely prohibited under federal law from asking these questions. I wanted to raise 2 quick points as to issues previously discussed. The law is ambiguous in a couple of areas. Agricultural property is defined as property suitable for farming. How is that determined? On its face, the language is extremely vague and broad. If I have a large garden in my backyard in which I grow corn, sunflowers, vegetables, that kind of thing, is that farming? What if I keep chickens and sell some of the eggs to my neighbors? Is that farming? In some states, we see a minimum acreage rule applied to this provision. And finally, HB 4234 includes restrictions within 20 miles of a military installation or key facility, as previously discussed. There is no way for us as title examiners, abstractors, settlement agents, and insurers to know if a property falls within that 20-mile prohibited zone. And with that extensive list of key facilities, we essentially would have to consider the entire state as potentially affected by this law. While we understand the legislature's goals from our vast experience handling and insuring real estate transactions, we feel best positioned to let you know this is something we have no way of determining. Section 36B1 requires a buyer of any interest in real property, in agricultural land, or within 20 miles of a military installation or key facility in the state to file an affidavit attesting the buyer is not a foreign principal and is in compliance with the law. Because of the broad list of key facilities under the law, including cell towers, as previously mentioned, and federal laws such as the Fair Housing Act, which prohibit us from asking the questions that we would need to know, virtually every buyer of any real property in Michigan would need to file the affidavit. Is the department even set up to handle these kind of volumes of filings? This is why it's critical that the reporting responsibility lies solely with the buyer, and there is no liability on behalf of our industry. I would thank the committee for their time this morning. It would appreciate the opportunity to work with the members and the bill sponsors to propose language to address the issues raised. Thank you.
Thank you, Mr. Martin. Do we have any questions? Okay, not seeing any questions. We'll move on to Kyle Zawacki, wishing to speak in opposition to the bill from the ACLU. Welcome, Kyle. Begin when you're ready.
Thank you, Chair, Vice Chairs, and committee members. My name is Kyle Zawacki, and I'm the Legislative Director for the American Civil Liberties Union of Michigan. The ACLU appreciates the opportunity to testify today and are here because of our opposition to House Bills 4233 and 34. To be clear, the American Civil Liberties Union of Michigan recognizes and fully agrees that national security is of paramount importance. We also believe that policies enacted in its name must not infringe upon the constitutional rights and liberties of individuals. However, these bills pose serious threats to civil liberties, privacy, and economic fairness in our state. We have 4 major concerns with the bills. First, the lack of evidence for national security risk. House Bill 4233 and 34 seek to prohibit foreign individuals and entities from purchasing agricultural land and real estate near military installations based on a presumed threat to national security. Foreign-held agricultural land represents an extremely small fraction of total farmland in the United States, and there's no data supporting the assertion that these purchases have led directly to security threats. Enacting legislation based on speculative concerns rather than concrete evidence undermines the principles of sound policymaking. Second, the discriminatory impact of lawful permanent residents and immigrants. These bills could disproportionately harm lawful permanent residents and other immigrants by restricting land ownership based on country of origin. Banning land purchases based solely on national origin or citizenship violates the principles of equal treatment and due process that are enshrined in the Constitution. This kind of discrimination could cause significant financial harm to individuals and families who are lawfully present in the United States and seek to invest in property for their homes or businesses. Third, the historical parallels to discriminatory alien land laws. This legislation recalls a dark chapter in American history when states passed alien land laws to bar Asian immigrants from owning property. In the early 1900s, these laws were justified using similar unfounded national security concerns and xenophobic rhetoric. Courts later struck down these laws as unconstitutional, recognizing them as tools of discrimination rather than legitimate security measures. And lastly, the unfair conflation of individuals with their governments. These bills unjustly conflate individuals from certain countries with the actions of their governments. Not all individuals from so-called foreign countries of concern are agents of their government, let alone nefarious ones, nor do they necessarily stand in agreement with all of their policies. Penalizing people simply because of their nationality contradicts fundamental American values of fairness and non-discrimination. Singling out individuals based on the actions of a foreign government are not only unjust, but also risk exacerbating xenophobia and anti-immigrant sentiment. Protecting national security and upholding constitutional rights are not mutually exclusive goals. Indeed, they are both essential to preserving the freedoms that define our democracy. For these reasons, we strongly oppose House Bill 4233 and 4244 and urge the committee to vote against them. Happy to take any questions.
Great. I don't see any questions. Thank you very much.
Thanks.
Okay, next up is Nicole Biber, wishing to speak, although she's neutral on the bill.
Good morning, Manu Gishigat. Thanks for the opportunity. Nicole Kiwi Biber, and I really appreciate the opportunity because I'm just here as myself. And I'm neutral because there's obviously, as we've heard, so many complicated factors in here. And I just wanted to raise up 12 through 15 really stood out to me on 4233. Pending the sale or disposition, the agricultural land is not used for a purpose other than farming, and the agricultural land is not used for farming except under lease to a person not subject to the restriction under subsection 1. So the first part of not used for a purpose other than farming, that was a big, exciting kind of point to me, because when we think about security, you know, I very much think in terms of the basics of food and water. However, with the part of the accept, that you know, kind of took the wind out of my sails a bit, because I think it's a matter of what is the interest in procuring these lands. And oftentimes it's to build developments. Oftentimes it's more industry under the guise of agriculture. And so when there's practices to cause concern that can come from a foreign entity, that can also come domestically if the result is something like losing the land to things like development, losing the ability for this to be agricultural land, that's a concern whoever buys it. Practices like inefficient water use, pesticide and fertilizer applications to the point of harmful algal blooms, the degradation of soil, so, you know, consolidation, all these stressors that, you know, these decade-long trends that kind of precipitate this cycle of debt or this sort of like go big or basically lose your home. So, you know, I appreciate the awareness that these bring of how precious the lands and waters are. It uplifts the seriousness and the importance of our responsibility to maintain the use for farming. But when I think farming, I think food and specialty crops, right? Not things like monoculture or CAFO so much, but this focus on, like I was saying, rebuilding soil, regenerative methods, restoring habitat to improve water. This is what I think assures our security in the long term, restores a measure of independence to us. And so I think, like, if I were to think of like a vetted legal refugee or a lawful immigrant from a family, you know, a family from a country of concern wants to become farmers using best practices to sort of enhance the soil and provide food, I wouldn't so much want to deter that. But, you know, when this question that, you know, Representative Vanderwall raised about entanglements with hedge funds, what are the profit motives, nefarious intent, you know, the enforcement complications, all these ambiguities, I think that the practices of farming can provide clarity about intentions. And so if what we're looking at is food-based sustainability, assuring that food security and that the responsible use of land and water in the long term is what the farm is being used for, I think that's something that provides clarity. Miigwech.
Thank you very much. Okay, we don't see any questions. Next up is Roland Huang, and apparently he's on Zoom. Are you there?
Yes, I am.
Okay, begin when you're ready.
My name's Roland Wong, and I'm with American Citizens for Justice, and a civil rights organization. I'm a lawyer, and I actually echo many of the concerns that were brought up by the representative from the American Civil Liberties Union, to the extent that while the bills are well intended in terms of citing security risks and working towards ensuring food security, that sort of thing, I think that there may be several unintended consequences, i.e., the idea of demonization of individuals who might want to purchase property, but they are citizens of one of those countries of concern, and they may well be lawful permanent residents or legitimately on a H-1B visa or F-1, whatever. Just the unintended consequences of people who are legitimately seeking to buy property and live on it. So that's the concern, and also the other issue about conflation of individuals with the governments of those countries that they come from. It should not be conflated, because there are a lot of people who come and want to earn a living or get educated and do not necessarily align themselves with the viewpoints of their particular home government. So I think that it's just a call for just some sort of way to ensure that there's an examination or a pause, some sort of administrative pause for the transactions that might be at issue, so that there can be a thorough vetting of the process, and that some conflicts can be avoided when, in fact, they are legitimately, just seeking to buy property for their own use. So, thank you very much.
Thank you very much. Not seeing any questions here for you. Appreciate your testimony. Okay, next up, willing or wanting to speak in opposition to the bill is Emily Nugent of Rising Voices. Welcome.
Good morning, Chairman and members of the committee. My name is Emily Wang, and I'm the Policy Director at Rising Voices. Rising Voices is an advocacy organization dedicated to organizing and developing the leadership of Asian American women, young people, and families in Michigan. And I'm here on behalf of Rising Voices to express our strong opposition to all the items on today's agenda. However, the main focus of my testimony will be on House Bills 4233 and 4234, which we have deep concerns about. We believe that these laws will significantly harm the Asian American community, which is Michigan's fastest growing racial group. It also threatens the broader immigrant communities who contribute substantially to our economy and have helped drive population growth over the last decade. First off, I would want to call these bills what they truly are: measures disguised as strengthening national security in our state, but in reality, they are nothing more than alien land laws. Alien land laws are not a new concept. If I may remind the committee and anyone watching that alien land laws are deeply rooted in racist and exclusionary history, particularly targeting Chinese and Japanese Americans, starting with the first alien land law introduced in California in 1913. This law made it so that aliens ineligible for citizenship were also unable to purchase property. The legality of today's bills remains to be decided, but the morality of these bills is clear. These bills dangerously echo some of the darkest moments in our country's history, one in which we seem bound to repeat. HB 233 prohibits foreign nationals from purchasing agricultural land in the state. and HB 4234 goes further by including real property within a 20-mile radius of a military installation or key facility, and specifically bans individuals from the countries of China, Russia, Iran, North Korea, Cuba, Venezuela, and Syria from purchasing property. The passage of these bills will have a chilling effect on Michigan residents and impact the economy and farming industry negatively. Specifically, it might deter new residents and businesses from relocating to Michigan, and it breeds an atmosphere of fear and distrust among neighbors and communities. These bills also raise serious legal concerns that I hope committee members will carefully consider, like the potential violation of the Equal Protection Clause of the 14th Amendment. As established by the 1948 U.S. Supreme Court decision in Oyama versus California, which ruled that restricting land ownership based on national origin or ancestry is unconstitutional. Naming the specific countries of concern to restrict nationals of those countries from purchasing property could open us to challenges on discrimination of a person's national origin, which is protected by multiple federal laws and the Michigan Elliott-Larsen Civil Rights Act. During this unprecedented time, where we have seen the forced disappearance of legal permanent residents, these bills incite further racism and xenophobic hate towards immigrant communities. A recent report by the organization Stop AAPI Hate found a 59...
I hate to cut you off, but in the interest of time, I'll have to have you sum it up. Okay, we got a couple more people. Okay.
Absolutely. I just want to note that there were questions about if these types of bills have been challenged in other states. Florida and Texas, I believe, are pending litigation. Just wanted to make that note. Thank you.
Okay, thank you. Okay, next, wanting to speak in support of the bill is Barry Adams. Barry, are you here today? Welcome, Mr. Adams.
Thank you.
If you could, please limit your comments to about 3 minutes.
All right.
Thank you.
When you do so unconstitutionally. That's Article 1, Section 5 of the Constitution.
Yeah, we did pass some rules at the beginning that I could limit that just in the best interest of time. Thank you.
Constitution says you can't do that. But anyway, Barry Wayne Adams out of Marshall, Michigan. I see there are concerns about foreign influence and how it's being applied. And although you're focusing on aspects of land ownership, there are other modalities of foreign influence that are just as nefarious and can have a negative consequence to Michigan and its internal integrity. One thing we should be concerned about is not just foreign actors, but domestic entities that will operate as proxies and facilitators and will collude with the process in bringing foreign control of national resources, of local resources. And this has already happened with the use of the Michigan Strategic Fund, Michigan Economic Development Corporation, and the various economic development corporations that have sprung up around the state to try to implement the intrusion of the CCP, like Goshen up in Mecosta County and Contemporary Amperex Technology Limited down in Marshall, to bring them into positions of economic influence and control, hegemonic influence and control in the local economy. And we don't like that. We were talking about this stuff 2 years ago, about what's happening with the Marshall Megasite and the Blue Oval factory plant and the CATL influence. And I've got a copy of a letter, I'll just read real fast. It's from the Select Committee on the CCP to the Homeland Security. We write to request the Forced Labor Enforcement Task Force immediately places Contemporary Amperex Technology Limited on the Uyghur Forced Labor Prevention Act. Newly discovered information reveals that CATL is affiliated with Xinjiang Production and Construction Corp., a paramilitary and state-owned system and the only entity expressly named in the UFLPA statute due to its egregious forced labor practices. So when you're connecting with these CCP entities, these fronts and proxies, and facilitated right at the highest level. Whitmer, Quentin Messer of the MEDC, rubber stamping all these things. But, and that whole process, it was done in order to circumvent the prohibition of Article 9, Section 18 of the Michigan Constitution, which prevents the use of public funds for private gain. So there's a lot of things that have to be cleaned up here, but try to find a document called Unrestricted Warfare, and you will see the nefarious motives, the ideological imperatives of the CCP. It doesn't stop at the border. They use these proxies to infiltrate into our country and then start imposing their organizational modalities to try to control the population. And we in Michigan don't want to become slaves of international agents or the CCP.
Sir, if you just wrap up your last comments, we appreciate you coming in.
Okay. I want you guys to do something about this. The CCP agenda is real and it's nefarious. And I hope you guys wake up to it. And it's been inserted into your system at the highest level. Clean it up.
Okay, thank you very much. Okay, there be no further business before the committee. The committee will stand adjourned.